Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to Episode 98 of This Week in FCPA for the week ending April 13th, 2018, the Sox Are Back edition. First, a word about our sponsor, Affiliated Monitors. Affiliated Monitors was founded in 2004, and it provides professional integrity, monitoring, and ethics and compliance assessments nationally and internationally across almost all industries. With its knowledge of effective ethics and compliance programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small and mid-sized companies and even individuals. Having served in over 700 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's ethics and compliance program, visit Affiliated Monitors at www.affiliatedmonitors.com. In this week's episode, Jay and I take a look at a potpourri of topics, including the Red Sox hot start at 10-2. Is there a upcoming healthcare focus in FCPA enforcement actions? We take a look at Mark Zuckerberg's testimony before Congress and what it may mean for Facebook down the road. We look at the SEC awarding yet another whistleblower over $2.1 million. We consider no-poach agreements and whether they violate antitrust law. We consider the Navex Global report that more hotline and whistleblower reports are turning out to be valid after corporate investigations. Jay talks about a great podcast involving Eric Feldman, SVP at Affiliated Monitors, our sponsor, and Tom Topolsky from Louis Berger about the role of a corporate monitor with a company. I discuss the new FinCEN rules on customer due diligence and ultimate beneficial ownership, which go into effect on May 11th, and where this may lead for non-financial corporations. I discussed my upcoming Conversant Roundtable presentations in Houston on April 17th, Dallas on April 18th, the new book, The Complete Compliance Handbook, and Jay details some of the speaking engagements of the principals at Affiliated Monitors. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. Tom Fox here, back for another episode of This Week in FCPA, episode 98 for the week ending April 13th. That's Friday the 13th, 2018, the Sox Are Back edition. Together with my co-host and cohort, Mr. Monitors himself, Jay Rosen, we're going to take a look at the week that was in compliance and ethics, starting with the notation that the Red Sox are leading the AL with a 10-2 start. They are already brawling with the evil empire situated in the Bronx, the New York Yankees. And so it looks like it's going to be a great baseball season, Jay.
I'm looking forward to that, and also looking forward to a potpourri of ethics, compliance, and FCPA stories. It's been a busy week, and why don't you start us off with number one?
So first up is an article by Joseph Spinelli and Lisa Murtha from Ankara, not the capital of Turkey, but the company, that talks about FCPA due diligence and healthcare M&A. They begin by noting in a conference recently, Sandra Moser, the acting chief of the fraud section of the DOJ, announced that there was a combination, or at least a collaboration, between the FCPA unit and the corporate strike force of the healthcare fraud unit to investigate healthcare corruption in the United States and abroad. And they drove that down to the FCPA by really talking about what healthcare companies needed to do in FCPA M&A due diligence. They certainly reiterated the point that companies need to engage in robust pre-acquisition due diligence and how important that is. They gave us some targets, or rather some lists of areas for inquiry that healthcare companies should engage in, such as, does the target company or its subs operate in a high-risk country? Do they operate in high-risk industries in addition to healthcare, specifically noting that healthcare is high risk because of the government officials associated with it? is the target company's, what is the target company's association with the foreign government or a state-owned enterprise? Does the target company have clear policies and procedures around anti-bribery, anti-corruption? And are there prior instances that the target company is engaged in bribery and corruption? Always an important review, but I think specifically in terms of acting chief of the fraud section, Sandra Mosier's thoughts on, or at least comments about the collaboration of the corporate strike force of the healthcare fraud unit and the FCPA unit, it's certainly going to presage or portend an increased scrutiny of healthcare in that area. So it's important that you engage in robust pre-acquisition due diligence as opposed to post-acquisition integration. Jay, probably.
So,
go ahead.
I just want to jump in for a sec. I know I sound like a broken record, and I've been saying this for the last 3 or 4 years that, with my background of doing middle market investment banking, unfortunately, when companies are coming together, there is that sprint to get the deal over the line. And what they want to look at is quality of earnings and look at, all the synergies that can happen and all the people they can lay off to be more profitable. But again, doing due diligence from an FCPA perspective does not seem to be very high on many bankers and strategic companies list when they're doing M&A. So I don't know how many years we've been cautioning people about success or liability, but it's real. And just to, underscore your point, if Sandra Mosier's talking about it and you're in the healthcare industry, I'm going to keep going back to my Fram Auto commercial. You can pay me now or you can pay me later. So, this is definitely a cautionary warning that should be heeded. All right, I'm off my soapbox.
Off the soapbox and on to Facebook, which was certainly one of the biggest stories of this week, probably internationally, Jay, was the testimony of Mark Zuckerberg. We explored this in depth in a recent recording for Everything Compliance, which will go up next week. So I don't want to either take away from that or really hit on the same topics. But I wanted to maybe look at it from a couple of different angles that we saw in articles this week. The first one was coming wave of litigation against Facebook. It's already been filed, class action litigation here in the United States. In an article by Sascha Matusak in the FCPA Compliance and Ethics blog, Joe Mont, my colleague at Compliance Week, took a look at some of the potential regulatory schemes that might go in place for Facebook. So I think the regulatory scheme is probably going to be the biggest one that compliance practitioners have to face. Both data protection and data privacy are going to be in the forefront, I think, of regulators going forward. Some of the questions will be, does the U.S. enact some type of GDPR-like legislation? Will there be something a little bit different than that? And then the questions, or at least one of the questions that I would pose, Jay, is say the United States either has something different from GDPR, not the level and robustness of data privacy protection that we see in GDPR, does nothing. Yet Facebook will be under GDPR in the EU and the United Kingdom going forward. Will Facebook and other international companies have to adopt a company-wide robust data protection, data privacy, and then, of course, push that out to all persons they do business with, giving you a business solution to the legal problems of data protection and data privacy. I've continued, Jay, to look at the commentary around what people thought of Zuckerberg's testimony, and although the commentary seemed to be that the House on day 2 did a little bit better in the Q&A part, it's the one of the bigger takeaways, or I guess three biggest takeaways, are that Zuckerberg comported himself quite well. He said the things that he had to say, which was apologies, deference, and would answer via follow-up questions he could not answer at the hearing. And that, I guess for me, Jay, one of the biggest was the disconnect we seem to have between the leaders of our political class and the leaders of the biggest burgeoning industry in America, which is tech, in the face of Mark Zuckerberg. Now, I recognize there are other faces of that, certainly Tim Cook, certainly Jeff Bezos, but this was Mark Zuckerberg's day in the spotlight, or at least the congressional spotlight. And he obviously looks very different. Is from a different generation, talks and thinks very differently than the political class. And it really struck me as how disconnected our political class may be from the next generation of entrepreneurial and business leaders that this country is engendering. Because in more traditional industry, certainly in my industry of energy and your former industry of entertainment, I think the leaders tend to be sort of in their 50s, maybe a little bit older, and finance, banking, those types of leaders tend to be a little bit older, and the tech guys are a little bit younger. Zuckerberg, for instance, founded Facebook in college and has been the CEO the whole time. And in his 30s. So really struck me, and I'm not quite sure where that difference will lead, but that to me was one of the more interesting things to come out of this hearing. And this is certainly something from the compliance perspective that we'll be following quite a bit going forward.
Yeah, I wanted to just point out a couple things in Joe's article that I thought was great. One, he brought up a name that I haven't heard in years called GeoCities.
Yes.
And he talked about the GeoCities FTC enforcement that took place in 97, 98. And, basically we're facing those same issues from 20 years ago. The other thing that was interesting in his article is he talks about a California assemblyman named Mark Levine and how he's trying to drive to have the U.S. adopt GDPR and to really drive this from the California perspective, because we have so many of these tech assets that are out in Silicon Valley, and he wants to, help drive the regulation, but also help the companies be competitive. And, it just kind of reminds me that I guess depending on whose numbers you use, California is either the 6th or the 8th largest economy in the world. And California has driven much of the EPA regulation, which our good friend Secretary Pruitt has done his best to dismantle. But it still does show you the economic power here in California. And although Governor Brown is ceding to President Trump and sending 1 or 2 National Guardsmen to the border, we still kind of do our own thing, and we have an agenda that we want to drive.
So, Jay, we had another whistleblower award this week, and if I can maybe set this up for you, we have now,
Sure.
The SEC has now paid $266 million to 55 whistleblowers, and over $90 million has been paid out literally in 2018 alone. So what did you see interesting in this whistleblower award, and do you see this continuing?
I think it's more the latter point, Tom, that if you kind of look at it in relative terms, 2.1 is not a huge amount, but when you already look at the numbers from this year, which you said in mid-March of this year, 3 whistleblowers were awarded $83 million. So that really kind of skews the data. And it really just shows that this program from the SEC has been extremely successful. And even though with a couple hiccups in terms of potentially losing some of your anti-retaliation, safety for the whistleblowers, they are still going to the SEC, and there's still a way that these companies can be prosecuted and the whistleblowers can be rewarded for their good information.
Jay, why don't you just take this opportunity to follow up directly, and we'll drop back to number 4 in a minute on the recent Navex Global report about what they've seen about hotlines and whistleblower reports. Seemed to be a nice follow.
Yeah. Harry Cotter wrote about this on April 10th in the Wall Street Journal, and we linked to it in the show notes. And more claims by whistleblowers whistleblowers are proving true as companies look into the issues raised, and fewer tipsters are telling their employees that they face retaliation. And the numbers that Navex has come up with is 44% of the 900,000 claims included in a benchmarking report proved correct. And that compares with the median rate of substantiation of 40% in 2016. So there's been a 4% increase. And this Carrie Penman over at Navex says that this increase is substantiated reports is notable, and it is an indication of maturing programs. At the same time, the percentage of reports alleging retaliation against employees declined from 0.66 to 0.66% from 0.93%. So that's happening too. And the only step that's in the wrong direction, the time it takes companies to resolve claims increased slightly. The median number of days needed to close an employee's claim rose from 44 from 42 in 2006. And putting a cap on the Journal's article, Scott Nelson, an employment lawyer at Baker McKenzie, spoke with Carrie Penman on a webinar, and he said, honestly, most employee claims should be resolved within a week or two, though some can take longer due to the complexity of an issue or difficulty reaching the people involved. So we link both to the data from Navex and the Journal article, and I would say it's just another confirmatory step in the way that programs are maturing, and people are taking heed of what's happening out there in the marketplace.
Next up, Jay, we had an interesting article by my Compliance Week colleague Jaclyn Jaeger in around the issue of no-poach agreements. And no-poach agreements are, for those uninformed, where two companies agree they want to purloin each other's employees, either for a set period of time or open-ended, or during a project, during the life of a contract. These are fairly common types of agreements, but the Department of Justice has recently filed a civil antitrust lawsuit against one of these no-poach agreements. And if that ruling goes forward as the DOJ has asked, and it could certainly impact the ability of companies to do this. Now, companies typically have employees sign non-competes, but and so you can't go to a competitor. But when you sign a contract with a business venture partner, a third party, someone at arm's length, that's generally not going to be a competitor. So the no-poach agreements can keep you from going to company or are being hired from company to company. And the clear legal and compliance risk here, or there is a clear legal and compliance risk that companies must be careful in negotiating both solicitation and non-solicitation agreements. Not all non-solicitation agreements are going to be illegal, but they may be for a wide variety. And I think this is something that we're going to have to keep an eye on. Companies need to be very aware of because, Jay, this is actually a fairly common tactic. And if it's upheld by the courts, as the DOJ has suggested, it could change lots of different contractual clauses, much the way we saw that in the retaliation cases for whistleblowing some time back. Jay, we had I thought, a really interesting, fascinating, and perhaps I could even say important podcast that came out this week on the SCCE Compliance Perspectives, which is hosted by Adam Turtletop. It has your colleague, Eric Feldman, and Tom Tobolewski from Louis Berger, and they talk about the relationship between a corporate monitor and a corporation. So obviously Eric is with Affiliated Monitors, and Tom, I believe, was formerly with Louis Berger. And I found it really interesting. I have seen them speak together at conferences, and the information they give is not only first rate, but certainly significant for every corporate compliance officer and indeed corporate senior official. So with that incredibly long-winded introduction, I hope I haven't stole your thunder and you can get into it a little bit more.
Yeah, well, thank you for setting it up that way, Tom. This is really timely, especially following last week's 5-part series that we did about corporate monitors. And my key takeaway from the conversation between Tom and Eric is that the really important thing that you need to have to make a corporate monitorship work is that you need to have a level of trust with your monitor. And, initially it's a tripartite situation because you've got a government regulator, you have the party that is being regulated, and then you have the monitor who's kind of in between. And part of the thing you need to do is develop this relationship. And you have to shift it from a perspective where your client who's hired you has to look at you as a partner and trust that you are there to do what's best to help correct the business and inoculate it from future recidivism. And, Tom and Eric really developed that relationship. And we feel, and they feel, that the company is much stronger 3 years into the process now. So sometimes you get into a situation and the monitor is looked at being a gotcha guy, that the monitor is there to do further digging and trying to get more stuff for the government to get on the client. And that is not the way that we approach this. I mean, other monitors might do things differently, but we generally become part of the solution, and we have the independent perspective to dispassionately take a look at a company, find out where the control failures are, and help them put in place a system to make them successful in the future. So I'd recommend, if you have 12 minutes, it's a real great podcast. I recorded it live at the recent SCCE-ECI in Frankfurt. And I believe Eric and Tom are going to be doing an advanced discussion group, will be based on this interview and what they presented in Frankfurt. And that's going to be added soon to the agenda for this October's CEI in Las Vegas. So good stuff here on monitors. And now I will throw it back to you on new FinCEN rules that are coming out regarding due diligence and beneficial ownership.
Sure. So FinCEN has issued FAQs around the new requirements for customer due diligence, which will go into effect May 11th. And this is for financial institutions, but it has a lot of great information, and I think indeed down the road applicability for non-financial institutions. So obviously banks focus on customers, and this is not something that non-financial institutions have typically done, customer due diligence around beneficial ownership and checking them out for potential AML or other violations. I think this is where non-financial corporations need to go. But there was a couple of things I wanted to highlight. The first is that and now, at least after May 11th, you're going to be required to gather information about your customer at account opening. And the key here, Jay, is it will be used to develop a baseline against which customer activity can be assessed for suspicious activity reporting. And think about that for a moment in terms of corporation. They rarely think about establishing a baseline of how a customer is going to act. So in terms of sales pricing, gifts, travel, and entertainment you might spend on a customer either pre-sale or post-sale, I think having that baseline is a pretty good idea. The second thing is on updating beneficial ownership information. There is a minimum standard of 25% interest in a legal entity, which requires disclosure to the financial institution. A financial institution can go lower than that, but that's the FinCEN requirement. I think that's something that non-financial corporations are going to need to take a look at. There's a relationship, obviously, between ongoing monitoring and this information, and that's something that compliance officers and corporations are going to need to take a look at. And then in channeling their inner Ronnie Reagan, there's certainly a trust level, but there's also a verification requirement. So trust but verify. So we're going to link to these full FAQs, and I think this is something that regular non-financial corporations are going to have to consider going forward. But I really want to emphasize that baseline, because that works in a wide variety of ways and with different types of corporate information. And I think by having a baseline of not only what the customer is going to buy from you, but your relationship with the customer in terms of gift, travel, and entertainment spend, length of time to get a contract signed, charitable donations you may make at their request, all of those are a great, establishing a baseline on that is a great way to see if something has changed and to really help you further operationalize your compliance program. So take a look at that.
Great. So this week, in addition to the Sox being back, Jonathan Armstrong was back in deep in the heart of Texas. What did you guys do this week?
So Jonathan was down in Houston. First thing we did was we had a 50% live recording of Everything Compliance as he and I joined, were together in the studio, joined by the rest of the gang. He also put on a GDPR event for the Greater Houston Business and Ethics Roundtable. I also hosted a breakfast roundtable where Jonathan brought us up to date on the Bribery Act, which was really interesting and very good. So a lot of good stuff. I took the opportunity to record some more podcasts on our Countdown to GDPR series that we'll be releasing over the next few weeks. So it's great to have him over. It's a really busy time for he and his firm, obviously, with May 25 as the go-live date, but he took the time to come over, so I'm certainly glad he did that. Jay, if I could give yet another plug for the Complete Compliance Handbook, which will be released probably late April, early May by Compliance Week. It's still available for pre-sale on my website. I've got a couple of events in the upcoming week. If you're in Houston on April 17th, I'm going to be leading or at least participating in a conversant roundtable on using data to drive ethics to the center of business. This really ties into my Innovation and Compliance podcast and where I think compliance is going and needs to go, which is using data to help more fully operationalize compliance. If you're in Dallas on the 18th, I'm going to be there leading a discussion on the same roundtable. And as we've said several times during this podcast, Jay, the Everything Compliance Gang recorded yesterday, and it's in production now, and that should go up on Thursday, April 18th. So hopefully we'll have some fans on that. In this podcast, we took two topics, which were the Zuckerberg testimony, Facebook Cambridge Analytica, and kind of dissected that. And then we took a look at the Michael Cohen subpoena. We looked at it from the legal perspective, the attorney-client privilege, and how all of that really relates, and the compliance officer needs to understand it. And it was less structured on this podcast, more free form, with lots of great questions and answers going back and forth from the panelists. So I think everyone who enjoys that podcast will certainly enjoy our next episode, Jay. Anything on the AMI or Rosen front we should mention?
If you happen to be in Singapore next week, Eric will be addressing the Public Sector Internal Audit PSIA conference, and he will be talking about how audits become investigations. And then on Tuesday of next week, the 17th, Vin DiCiani, the founder of Affiliated Monitors, and Donald Sterling will be in London for an event with our strategic partner, RS Legal Strategy, and they will be welcoming David Kirk to the firm. So it's nice for our folks to get out to the UK and connect with some of our contacts over there. So that's what's happening from Affiliated Monitors perspective. And I think once again, we've made it through another week. I think with what happened this week in terms of Cohen and the Dawn raid, I think it's very present. Wasn't it last week ago that we had an article from Mike about what you do when the FBI comes a knocking? I'm not saying we predicted this, but it's certainly not surprising, and it's also good to have the advice of Mike and the other folks in the Everything Compliance Roundtable. So, on behalf of Tom Fox and myself, Jay Rosen, we'd like to thank you for joining us for this week in FCPA, episode number 98, the Sox Are Back edition. We thank you for coming and listening to us and talking about ethics, compliance, and FCPA, and we wish you all a great weekend.
Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of This Week in FCPA. If you have any questions, you can email me at tfox@tfoxlaw.com. You can email Jay at j.rosen@affiliatedmonitors.com. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out about the only weekly wrap-up of all things FCPA, compliance, and ethics related over the past week. This Week in FCPA is a part of the Compliance Podcast Network.